So greetings to all. My name is Jose Alvarez. I'm the faculty director of the U.S. Asia Law Institute at NYU, and you're tuning in to the second of a four-part Jalat dialogue on rule of law in East Asia, focusing on climate change in the Asia Pacific. Before we start today's interesting program on sea level rise, I want to tee up the next one. This will be the third one in the Jalat dialogue, which is tomorrow at 9 to 10 a.m. That is Eastern Standard Time, and it is on U.S.-Japan partnership in climate change. As I think the first panel, if you were part of that, mentioned, there are various side agreements trying to deal with, mitigate, especially climate change. And tomorrow's focus will be on the U.S.-Japan partnership, and it'll be introduced and be moderated by Bruce Aronson, who is a resident affiliated scholar with USALI, and I hope you can tune in to that. So today's, the second Jalat dialogue is on rising sea levels in Asia, and I'm very excited to introduce that, especially given who is on this panel. So before I briefly cover their bios, and I'm not going to spend too much time on their bios because it's on our website and I don't want to steal from their time, I just want to tee up the topic for those of you who haven't followed it as closely as others. So rising sea levels due to climate change are affecting the livelihoods and perhaps even the life and certainly the place where they live of many millions of people around the world. Our focus is, of course, on the Pacific region. And most of this concern here is on adaptation, which is a bit different from the first panel that was discussed last night, which was on the Paris Agreement and the Committee of the Parties process, largely focused on trying to prevent or mitigate climate change. The panel today is focused on the reality that whatever happens with respect to the COP process, rising sea levels are here to stay. We may hope to mitigate them a bit, but the impact will be felt regardless of what we do. And therefore, this panel is talking about principally how best to deal with them, how to adapt to those changes. And for international lawyers like myself, it's a fascinating topic because it affects boundaries. It affects the movement of populations, basically climate change migration and the protection of persons. It affects deeply law of the sea issues, including questions about what states can or cannot do with respect to adaptation, whether building on islands, fortifying rocks, fortifying other structures. And there is the possibility as well that it deeply affects the very notions of statehood and what it means to be a state. It could, rising sea levels, leave some island nations practically or in reality without any territory at all. So today we're extraordinarily privileged to have two of the five, I believe, co-chairs of the committee in the International Law Commission, who were part of, in 2012, the ILC established a new committee on international law and sea level rise, and they've been working ever since then. As I understand the plan, it's to produce various studies devoted to the three issues that I've mentioned, that is law of the sea impact and issues, impact on statehood questions, and impact on the protection of persons. And I think we're very fortunate to have Nilüfer Oral, who is looking especially at the law of the sea questions, and Patricia Galvotelvis, both of the ILC since 2017. I believe you've both been members, and of course, members of this committee. And you'll be focusing on that. Our own adjunct professor and resident expert at NYU, Bryce Rudyk. I will perhaps send him a few questions when it's my turn on the statehood questions that I think would otherwise not be addressed. So one thing that I was asked to do before I introduce a bit more of the speakers is to say a few words about the International Law Commission and what it is to those of you who don't follow it. So the General Assembly has under the charter a mandate to basically promote the progressive development and codification of international law. Early on, it established the International Law Commission, which today has 34 experts, including folks from academia, the diplomatic corps, government ministries, and international organizations. They're elected in their individual capacities, not representing their member states, but they're elected on their capacity and recognized competence to discuss issues of international law. What is interesting about the International Law Commission, for those of you who don't follow it, is how its mandate has somewhat changed over the years. In early years, the greatest hits of the International Law Commission tended to be treaties that we all study in our basic international law classes. This includes everything from the Vienna Convention on the Law of Treaties to most recently the Rome Statute, where the Rome Statute for the International Criminal Court, that is. And basically the International Law Commission was I'm trying to get rid of a screen that somehow popped up in my screen, but I can't seem to get rid of it. I don't know why that happens, but so before I just leave, I want to make sure that people understand the 6 topics that are within the 73rd session of the ILC, and to suggest, and perhaps the 2 folks from the International Law Commission will correct me, but I don't see the International Law Commission today as being devoted to draft treaties. And that most of the topics that I see, which are immunity of state officials from foreign criminal jurisdiction, protection of the environment in relation to armed conflicts, preemptory norms or jus cogens, succession of states in respect of state sovereignty, a study on the general principles of law, and this particular effort on sea level rise in relation to international law. I think the goals here are variations on reports, such as their fragmentation report on international law, guidelines, or perhaps draft articles. This is a very different approach from the traditional drafting of treaties that will be sent to states to negotiate. So again, we're very privileged to have Nilüfer Oral. Let me just say briefly, she is the director of the Center for International Law at the National University of Singapore. She's been a member of the UN International Law Commission since 2017. She has advised the Foreign Ministry of the Republic of Turkey on matters related to the law of the sea and climate change, and has served as a climate change negotiator between 2009 and 2016, including attending sessions of the International Maritime Organization. Patricia Galvotelvis is a professor of international law at the Autonomous University of Lisbon, senior legal consultant on international law at the legal department of the Portuguese Ministry of Foreign Affairs. And she's been focusing on the protection of persons, including displacement and human rights issues. She's also a member of the Permanent Court of Arbitration, and their interlocutor, Bryce Rudyk, is director of the International Environmental Law here at the Guarini Center on Environmental Energy and Land Use Law. He also teaches here at NYU. He is the legal advisor and chair of the Alliance of Small Island States at the UN, which is currently chaired by Antigua and Barbuda, and is the negotiating group on climate change, sustainable development, and ocean issues for the 39 small island states. So I turn it over to Bryce, who will tee up. I believe Nilüfer will go first, but if Bryce, you want to say a few words, please. Thank you.
Just to say that I'm the legal advisor to the chair, not the legal advisor and chair.
Sorry.
The ambassador may get very mad if I usurp his position. But I think we should just jump into it. In the chat, I've put a link to the initial curriculum that was adopted by the ILC in 2018, which guides the work of this study group and includes the questions that both Nilüfer and Patricia have already looked at and are currently looking at. So perhaps on the issues of law of the sea, Nilüfer, you could start.
Thank you, and greetings to all from Singapore. I would like to thank Jose and Catherine for this invitation to be here with you, and it's wonderful to see Bryce. We've known each other for a number of years, particularly in the context of sea level rise, and of course, my dear friend and colleague, Patricia. So it's a big topic, and we have limited time, so I'll do my best to give you at least a flavor. And I do have a PowerPoint, a flavor of the law of the sea issues that are so critical in relation to sea level rise. And I won't go into much detail on the history of the topic in the commission, but if there are questions, we can talk about it later on. And I will focus, of course, on Asia as much as possible, or at least Southeast Asia. But very briefly, the IPC 6 report is out. It is the news is dismal, it's depressing. But one thing we've known for a very long time, actually, is that sea level rise is happening. And it will continue to happen even if we were to go to absolute zero emissions right now. There is a certain degree of warming that is locked in, and sea level rise that is locked in. And in fact, the studies show that it's probably more than originally projected. And the estimates that we know from the IPCC, but frankly, these are conservative estimates. But on average, the global level of sea rise based on a high emission rate, and we are certainly on that pathway right now, would be about 1.1 meters, but that's on average. And for example, certain regions like Asia will experience a higher level of sea level rise. And I just have to say, the science shows that we're experiencing more sea level rise, faster sea level rise since 1900 than in the last 3,000 years. And I think what we're seeing is that, except perhaps for the Pacific Islands, the small island developing states who have been really raising this issue for 30 years, since 1989, a lot of states really are not prepared, and I include Asia in that. So I will continue, I keep tabs on the time. So in the International Law Commission, I am co-chair with Bogdan Orescu, and we prepared the first issues paper on the law of the sea issues. And the law of the sea issues have to do with, of course, multiple issues, but sea level rise, basically, as sea level rise, and this I think depicts it, you'll see how the sea will encroach upon land. You have a landward movement of the sea, meaning there's going to be coastal erosion. And this is a great PowerPoint from colleagues from the World Maritime University. And it shows you, I think, very nicely how the sea is moving. So yes, there's loss of land territory, and it brings in many, many issues. But one issue concerns specifically law of the sea issues, such as maritime boundaries. And those maritime boundaries are built upon baselines. And I don't want to get too technical. We don't have time, but there are some issues that are raised by sea level rise in the law of the sea context, both under the convention, the law of the sea convention from 1982, but also what we might call international law, because not all states are parties to the law of the sea convention. So some of those issues, and these are issues that we took up in the International Law Commission, both in our first issues paper and then in the study group, which is a broader group that includes more members of the commission, whether that baseline, which is the starting point for all maritime boundaries, is ambulatory. Does it have to change because of the landward movement of the sea, which will change it, which will result in certain base points, such as small islands or coastal projections, which disappear? Do states have an obligation to review and change their baselines? There are questions concerning the charts that are used. One other issue that comes up concerns archipelagic states, and also what happens to islands and their entitlements. What about the status of existing maritime boundary agreements? If those baselines change and there's a landward movement of perhaps the outer limits of those maritime zones, would those maritime agreements change? And this is just to give you a visual depiction what I'm talking about. We have important maritime zones. You have the territorial sea, and the baseline from which that territorial sea measured is the starting point for an exclusive economic zone, which goes up to 200 nautical miles. But that could be much more depending on if there are islands that are also entitled to these zones. And the coastal state has very valuable exclusive sovereignty rights over this area. And then, of course, you have the continental shelf, but really what we're looking at is the territorial sea, the exclusive economic zone, because these could be impacted by the landward movement due to sea level rise. And what that could mean, for example, is that if the exclusive economic zone boundary were to move landward, that means an area that was once under the exclusive sovereignty of the coastal state would become an open access regime of the high seas. So the impact could be quite significant, but it all depends. These are questions that still have to be resolved as to how much would they be impacted. But this is something that international law is examining because we don't have clear answers. I mentioned archipelagic states. It's a very complicated formula, but basically an archipelagic state, if it meets this complicated formula, can have a maritime area based that is would enclose the whole sequence of islands, starting from the outermost points of the outermost islands and drying reefs. And this is very important. This is something that the archipelagic states really, for many, many decades had wanted, and finally with the Law of the Sea Convention, were successful in attaining. But because of this complicated formula, which relies on these outermost points and outermost islands and drying reefs, what happens with sea level rise if those were to disappear, be submerged, and that ratio, 9-to-1 ratio, would change? Would they lose those very valuable archipelagic waters? Islands. An island that is defined under the Law of the Sea Convention as naturally formed and is above water at high tide, and if it meets the criteria of being able to sustain human habitation or an economic life of its own. The article is written in a strange way, but it gives all the maritime entitlements: territorial sea, continental shelf, exclusive economic zone. But if it's a rock, meaning it cannot sustain human habitation or an economic life of its own, then it is not entitled to that very valuable exclusive economic zone and continental shelf. And a low tide elevation, which means it's submerged, gets none of these. The question then is, what happens if an island, and this is actually happening, becomes uninhabitable, meaning that it can no longer sustain human habitation? Does it devolve into a rock and then lose those very valuable maritime entitlements? A lot of states are going to be directly affected by sea level rise, and even more indirectly, but I'm going to go on. So I'm going to just focus a little bit on on Asia, because rightly so, we focus quite a bit on the Pacific Island, the Pacific region, the small island developing states, because they are truly the most vulnerable. But Asia as well, and particularly Southeast Asia. For example, Vietnam and Bangladesh are in the top 5 countries that will be most impacted by sea level rise in the world. But there are other countries in Southeast Asia as well. Singapore, where I live, Thailand, China, Indonesia, Malaysia, 2 very large archipelagic states, Philippines and Indonesia. In fact, there was just in last year headlines based on research that was done to measure sea level rise based on satellite readings. And what it showed was that, in fact, sea level rise is actually happening at a much greater level than the original, shall we say, less sophisticated methods of modeling were showing. And that, for example, according to this study, that Indonesia was looking at much more sea level rise than originally modeled. And frankly, the IPCC is modeled on the more traditional method. So we know that Asia is going to be highly impacted. And Indonesia, for example, it's one of the largest archipelagics made up of many islands, but it could also experience significant sea level rise. And in fact, already islands are sinking and others are on the verge of sinking. And some of these islands could be quite critical to its status of being an archipelagic state. So here are just some of the islands. Northern Java already succumbing to sea level rise. Betet Island, Gundul Island are submerged because of climate change. In East Java, they're losing land significantly. So sea level rise isn't in the future, it's happening right now, and it's happening in Indonesia. Also, I want to say that Indonesia has several maritime delimitation agreements. And what we have to take into account, one of the questions, of course, is what happens to these agreements? Is it pacta sunt servanda, regardless of whether actually their sea level rise results in changes to the baselines, and consequently, the question of whether there would have to be a change to the outer maritime boundaries, would they have to be renegotiated? This is a very important issue, a very significant issue, because as many of you may know, these types of maritime boundaries take years to negotiate. Maritime boundaries are some of the most sensitive issues, and frankly, they come at a cost as well. So these are real issues that need to be examined. I'm conscious of the time. We have in Vietnam. Vietnam is a very vulnerable, particularly the Mekong area. And already they're experiencing sea level rise. And again, this is something that can impact their coastal area. They have a very long coastal area that could be impacted. And once again, what does that mean for their baseline? How that can impact maritime boundaries, agreements that they already have, and others that are awaiting perhaps to be determined. So I'm going to go very quickly. Singapore, where I am, is a small island state. It is 20% reclaimed land. Singapore government has made it very clear that sea level rise is an existential issue. About 30% is less than 5 meters above mean sea level. They've already dedicated some $100 million over the next 50 years to 100 years to adaptation measures. So this is something that is very important for Singapore. So we've already talked a little bit about the ILC. In 2020, my co-chair, Bogdan Oresco, and I, we completed our first issues paper. We had our first study group meeting last year in 2021. We came to certain observations that were discussed in the study group. I have to say that the result is that, of course, there are different views. But in our view, our observation, the two co-chairs, we basically concluded that the Law of the Sea Convention really does not address these issues directly, because at the time of the negotiations and when it was adopted in 1982, climate change was not an issue, sea level rise was not an issue. Furthermore, we took the position that there is no express requirement that new baselines need to be drawn, or that baselines, that the charts need to be reviewed and updated, and that the ambulatory theory, meaning that the view that the baseline is ambulatory and does have to be changed, really doesn't meet the needs of states who are at very high risk of having their coastal areas erosion and baselines impacted, as well as, of course, then their maritime zones. So that's the view. But what I want to end on is the Pacific Island states have been very active, and Bryce has been working with them. And in 2021, they issued a declaration, basically, I think, echoing these views, that the convention, the Law of the Sea Convention, imposes no affirmative obligation to review and update established maritime boundaries. And I think that's critical, that these are boundaries that have been established and are consistent with international law and the Law of the Sea Convention. And they've basically declared that once their maritime boundaries are established, they have no intention of reviewing them and changing them in face of climate change and sea level rise. I raise this because since we're focusing on Asia, I think Asia is behind on these issues. And I think they are now, of course, catching up. And so I'm very curious to see what position, particularly in Southeast Asia, particularly those vulnerable states, including the archipelagic states, what position they will be taking on this. So I will stop here, and I apologize if I went over time.
No, that was great, and a good overview of what is a particularly long and detailed paper. And I've certainly said this before. I think that your paper, you and Bogdan, did an excellent job of explaining what is a relatively complicated area of law, the changes to it, and in fairly clear language. So I put the link in the chat. If anyone has some spare time to read 80 pages, I would certainly encourage you to do that. I just want to make one quick observation around the nature of EEZs and how islands, and in particular small islands, may sort of be disproportionately affected by rising sea levels. So if we think about the EEZ, which is 200 nautical miles off the baseline, if we think of a coastal country, which generally has sort of a straightish coast, the area of that EEZ is really determined by the formula of a rectangle. And as sea level moves inwards, that rectangle of EEZ just also moves inwards. So the area of the EEZ doesn't change that much. But for a small island, generally we think about it as a circle, and they're generally circular. Their EEZs are also then circular, and the area of a circle, if we remember from high school, depends on its radius, its width. And as that shrinks, the area of the EEZ actually shrinks exponentially as well. So this is just, I think, one area, and we'll talk about this a little more later, where islands and small islands may be disproportionately affected by this. But let's go on to Patricia to talk about the issues of protection of persons and the implications of sea level rise on that.
Thank you so much, Bryce. It's really a pleasure to be here with you and with Nilüfer and under the moderation of Jose. I'm very grateful for the invitation and to be able to discuss also this issue of sea level rise in Asia and Pacific from the perspective of protection of persons affected by sea level rise. As you understood from the presentation done initially by Jose and then from Bryce and Nilüfer's presentations in the International Law Commission, we are dealing with the issue of sea level rise from three different perspectives of the impacts of sea level rise in three different areas. They're not, of course, all areas that could have been identified in terms of legal implications, but those are the ones that, as Bryce mentioned in the syllabus that we've prepared for to 2018 when the topic was approved, we proposed to work on the areas of law of the sea, statehood, and protection of persons. And we've divided the work accordingly, and Nilüfer has already spoken about the work that has been carried out so far on law of the sea issues. And this year, according to our schedule, according to our plan, we have prepared a second issues paper to complement the first one that touches upon the other two subtopics. So the topic of statehood and the topic of protection of persons. I'm not going to deal with statehood because I understand that Jose has given that task to you, Bryce, and actually in the paper that we've prepared, it's not out yet. You cannot unfortunately put the link, but soon the paper will be public. It's now in the process of translation and of production as an official UN document, so it will soon be public. But we've also divided the work, the leads for each part of the topic to the different co-chairs, and sea level rise and statehood is being addressed by our very dear colleague from Peru, Juan Jose Ruda Santolaria, who has prepared for the issues paper, the part on statehood, and I have the lead responsibility for the protection of persons affected by sea level rise. So this is what I'm going to focus on. And of course, the paper will have both subtopics. And so I normally describe this subtopic, the protection of persons, as the human face of sea level rise. It's probably the best way to describe this, because sea level rise has an impact on territory, on government, but it also has an impact on people. And so this is what we are working on also. And Nilüfer has facilitated my task very much when she presented very well how many regions of Asia and the Pacific are affected. And this is very much highlighted in the reports of the international intergovernmental panel on climate change. The IPCC reports have identified, and if one just speaks about most recent reports like the 2019 report on oceans and the cryosphere, and the one that just came out at the beginning of this month on vulnerabilities, they show very well that Asia Pacific area is an area where the impact is going to be felt, and it's already being felt. And the most vulnerable states for sea level rise, also for the purpose of protection of persons, are the small islands in the Pacific, and also states with low-lying coastal areas, including Bangladesh and Vietnam, for example. So sea level rise for people poses a significant threat in terms of the impacts, the physical impacts, because they expose coastal populations to losses of land due to exacerbated risks of destructive erosion, inundation, wetland flooding, and consequences for infrastructure, settlements, agricultural lands located near the coasts. There's also a phenomena of saltwater intrusion into rivers and aquifers, which causes the stress on supply of freshwater resources. So it makes life more difficult, if not impossible, in certain areas for the population that live in those areas. And also this combined with the phenomenon that scientists have identified of sea level rise, combined with severe weather events such as tropical cyclones, even aggravate further the physical changes that I've just mentioned. And this is not only a significant threat, but it's a threat with a multifold dimension and intensity that has the potential to affect the enjoyment of human rights. Although we cannot say that sea level rise violates human rights, it certainly can be said that climate change, including sea level rise, can have an impact on the enjoyment, can have an adverse impact on the enjoyment of human rights. It also can lead to movement of persons. So not only this adverse impact on the right to life, right to health, right to water, right to food, right to an adequate standard of living, right to housing, and other human rights, there is a significant threat that may lead people to be displaced, whether they have to move internally or they have to move across borders. So this type of phenomena has an impact whether people are able to stay or whether they may have to move as a way to adapt. Relocation in the first place is seen as one way to adapt to sea level rise, but in the most extreme scenarios, migration, cross-border displacement will also be a measure to face the risks of sea level rise. What we have now is the absence of a dedicated legal framework to deal with this new phenomena. There is no specific category, although sometimes in public opinion and even in legal texts, there is reference to climate refugees or climate migrants. There isn't a specific legal category to address this new phenomena. Although certainly if we look, and this is what we've tried to do in the issues paper that has now been prepared, if we look at existing human rights law, refugee law, migration law, disaster law, and even climate change law, we can see some applicable principles and norms that could help to address this issue. So what we've tried to do in the second issues paper, and this is going to be discussed in the Commission this spring and summer, and then with states in the sixth committee in the fall, is to identify the existing legal frameworks and what tools, what obligations that are relevant arising from those legal frameworks. And also, we've also tried to map the existing state practice and practice of international organizations in this area. Of course, we don't have yet enough information. I think this is an important issue that states are now beginning to follow and to prepare better. I mean, we see that there is clear more information available about practice from states that are in the front lines of sea level rise, especially from the Pacific islands. But other states are also starting to prepare, whether they are low-lying coastal states like Bangladesh or even third states. And for that purpose, it's very interesting to note that the US, the White House, has adopted an important report on climate change and migration, where it identifies the need to look at the legal gaps and also the legal possibilities in terms of attributing, for example, temporary protection status to people that come to the US or go to the US as a result of climate change impact. So different states are taking different approaches depending also on their positions, but the practice is not yet fully developed. And I think this is going to be very interesting, like it was with the case of law of the sea, that we see states also understanding how they have to take measures and how they have to prepare legally for this new challenge. So in the commission, we've outlined in the paper, we've outlined a number of questions for the study group to discuss. Probably we will have an initial discussion this year, but the work is not going to be finalized now. It's going to take a bit more time for the commission to come up with a final report. As Jose mentioned in the beginning, the commission, there have been other cases where there's been a study group with the mandate to prepare a report on a certain issue, like the fragmentation study. And we hope that when we have had enough discussions on the different three subtopics, we can prepare a final report for states to use. So in terms of the protection of persons, the issues that we are discussing will be issues trying to identify what are the principles that are applicable or should be applicable to protection of human rights of persons affected by sea level rise. In terms of the substantive obligations with regard to the different human rights that I've already mentioned, right to life, provision of cruel, inhuman and degrading treatments, the right to adequate housing, right to food, right to water, right to take part in the cultural life of a country, the prevention, the right to nationality and prevention of statehood, rights of children, and rights of indigenous peoples. We'll also be discussing what are the procedural obligations regarding to public participation, access to information, and access to justice. What would be the non-refoulement obligations for third states? And this is an important question that arose in a Tetiota case, a case that was submitted by a national from Kiribati that was deported to New Zealand. And this is a case that was taken to the Human Rights Committee of the United Nations. And also what would be the principles that are applicable to situations where people have to move in case of sea level rise, whether they're just being evacuated, relocated nearby, or displaced internally, or even migrate abroad. There's one last question also that I think is worth discussing, and we are going to suggest that, although in the issues paper we've prepared, it's not yet fully developed, but I think it's an important issue for how states will cope with the issue of sea level rise, which is the question of international cooperation. Because it seems that looking at the situation of states that are more affected, that are directly affected, that it will be certainly difficult to resolve this issue without a certain measure of regional cooperation or even a more global cooperation. So these are the issues that we've mapped, that we've outlined, and that we will discuss as a contribution to identifying the existing legal norms, what might need to be developed in order to make states more prepared to deal with the human face of sea level rise. So I'll stop my remarks here. I hope I didn't go too much over time, and I look forward to the discussion. Thank you.
Oh, great. Okay, great. Thanks very much to both of you. So I have a whole number of questions, and well, let me just start. So following up on Jose's introduction, I wanted to ask about the relationship between UN member states, the International Law Commission, and then the General Assembly's Sixth Committee. So unlike the International Law Association, which has done similar work, the work of the ILC seems intimately tied to the legal opinions of states. Can you talk about how this relationship has shaped both your work and the conclusions that you've come to in your work? That's for both of you.
Okay, well, I'll step in and then let Patricia. Yes, as you rightfully highlighted, the International Law Commission, and Jose mentioned, is a subsidiary body of the General Assembly. It is an expert body. And we have direct relations with states, which is really important. That is a very big difference from the ILA, which has done really excellent work on sea level rise. But we have an active dialogue, an interactive dialogue with states, and particularly through the 6th Committee. And I have to say, in the case of Law of the Sea, it has been, there's without question, I mean, states' views are very important to the work of the Commission, but the Commission also does see itself as an independent expert body. One of our important functions, and I think Patricia brought that out, is also to identify state practice. But it so happens that, for example, the Law of the Sea, and I won't address Patricia's issue, state practice isn't necessarily so obvious in this area of sea level rise, and we've identified the gaps in our issues paper and their ongoing discussions. So for us, the state views are extremely important for a number of reasons, but one, as I said, to gauge state practice, at least through statements, verbal statements, or written responses to our questions. We have, for example, made a request that we can do that, for example, the ILA can't, or the Institute National can't, directly to states, asking them for any state practice that they can provide us that is remotely related to sea level rise and these issues. And that's important so that we can do our work and identify state practice. So we've gotten some feedback, but really not a lot. But in terms of guiding us, it is important. One thing that, for example, that has come out very clearly through the many, many statements, I have to say we've had a really robust response from states, is the importance of stability, certainty, and predictability when it comes to the issue of sea level rise and its relationship to maritime boundaries, maritime delimitation. Although the question is how one interprets that. Does that mean it's interpreted in favor of, preserving boundaries, or really not touching the Law of the Sea Convention, etc. So all of this has been extremely important for us in guiding our work, and it will be. We look to states. It's very important, and we will continue to look to states. That is why I think that our work generates responses that maybe we would not have in this area, that really doesn't have as much state practice as you would need for purposes of codification. So we haven't made conclusions yet, observations. The study group is still in discussion. The annual report is out. It's an ongoing work, but the state views will be very important.
Maybe I'll just add a few thoughts. I mean, one, even before everything that Nilüfer said, the starting point of the inclusion of the topic in the Commission's work was really state-driven. There are different ways that the Commission can use to pick topics, but traditionally the Commission has, an inside approach to this, in the sense that most topics are proposed by members of the Commission, individual members. And here we had individual members proposing the topic, but we also had, in a very unique moment for the history of the Commission, because this was probably the first time and only time that a member state, actually from the Pacific, the Federated States of Micronesia, proposed formally this topic for the Commission's consideration. So at the same time as in the Commission, some members, where Nilüfer and myself are included, were making a proposal. And I have to say, and I think Nilüfer can confirm that also our initiative was very much influenced by informal discussions that we had with member states in New York in the framework of the 6th Committee, where we were listening, where we were hearing this message that this is a good topic for the Commission to take up, because it's a new phenomenon, it's a new challenge, we need to understand a little bit more the legal implications before the political decisions can be made with regard to how the international community should deal with this. So even the inclusion of the topic in the agenda of the Commission was very much influenced by informal contacts and messages that were being passed to members of the Commission that this would be a good topic. And when we initially, putting a topic in the agenda of the Commissions is a two-step process. First, we do the syllabus and it's an annex to the report. And when this was done in 2018, about 120 states in the General Assembly spoke in favor of the inclusion of the topic, and many of them asked for the Commission to deal with this in an urgent matter. So there was a lot of strong support for the inclusion of the topic in the agenda of the Commission, formal proposal by the Federated States of Micronesia. And so here we see how this is a process that there's a constant interaction between the Commission and member states, which is really very different from what happens in the International Law Association. I'm also a member of the ILA committee that deals with sea level rise and international law. And the process is very different in the sense that there's no interaction with states. And here we have that interaction in the beginning, and we have it as the topic develops. And I think this interaction has been very useful and a very interesting development, because it's also in a way generating practice. So the fact that the Commission is studying and presenting issues papers and then annual reports makes states a bit more proactive, and they react, and they, I think that it's from this joint process that the responses will be shaped. So just wanted to add those additional comments.
Thanks. Thanks very much. So Nilüfer, a key phrase in the first issues paper was preserving legal stability, security, certainty, and predictability. And we've seen that phrase echoed both, well, not both, but in state interventions in front of the Sixth Committee. We've seen it in the Pacific Islands Declaration. We've also now seen it in the AOSIS Heads of State Declaration. Why was this phrase in particular important, and how did it sort of shape the conclusions that you made in the first issues paper?
Thanks, Bryce. Yeah, absolutely. You're so right. I mean, if there was one common theme that resonated in the statements by states, regardless of their position on this whole issue of ambulatory or non-ambulatory, was exactly the need for stability, predictability, and legal certainty. And that is in terms of preserving, of course, peace, good relations, legal certainty, and particularly in the area of law of the sea and maritime boundaries is fraught, as we know, with potential and actual conflict. This just came out so strongly, and it was very important in the issues paper, very much so, because, and I may not have actually brought this out clear enough in my initial presentation, but the issue comes down to whether under the Law of the Sea Convention, and this is the position that was taken by the Pacific Island Declaration, and of course you mentioned the AOSIS Declaration as well, the preservation of existing lawfully established maritime boundaries and maritime zones, and that would actually promote that legal stability, certainty, and predictability. Versus if you took the position that there's an obligation to change the maritime, the baseline, the associated maritime boundaries and zones, and have a landward shift, And if that were to apply, that would certainly, definitely create the possibility for instability. And we know, for example, fisheries is such an important issue. You mentioned exclusive economic zone. If there would be an area of the exclusive economic zone, that would shift. And I'm not an expert in mapping on this, but there are experts. That area that would become, and there's no such thing in my mind as a small area when you're talking about maritime zones and the natural resources that go along with them. And we're talking about very valuable fisheries, or, you know, there could be other natural resources. That could create instability, definitely. That could create conflict. So these are very key, and I think that they are absolutely crucial to our observations in terms of the observation that we came to, that preservation, that the current status of the Law of the Sea Convention, frankly, is not clear. State practice is not clear on this point. And that the preservation of entitlements would certainly address many of the concerns that those states most vulnerable, such as the Pacific Island states, but frankly, Asian states as well. So that's the first issues paper, but I should underline that is not the view of the Commission entirely. The Commission is still debating it. We have different views in the Commission. So I should make that point clear.
Yeah, based on the report that came out last year, it certainly does seem that there are different views in the Commission, but what I was sort of struck by in the States in the Sixth Committee responding was that states didn't really have different positions, that many were sort of quite on board with this idea of promoting legal certainty. So obviously, when we're talking about sort of boundaries and maritime entitlements, certainty is important. But I wonder, Patricia, if this extends into the work that you were looking at, and whether there's sort of a similar need for certainty and stability when dealing with the rules around protection of persons.
Maybe it's manifested in a different way, but I think the idea that if we have a clear understanding of the situation and a clear legal approach, that will be helpful for everybody. I think it's probably a little bit different in terms of how, because we don't have the issue here of the, the stability of borders or the issues that may arise from that lack of stability. But I think the issue of certainty, predictability in general in law is helpful. It promotes certainly solutions that might avoid conflict or might avoid, for example, I mean, if we think about the issue of migration and displacement, and if we think about, the main message in the last few years, especially after the refugee crisis, migration crisis in the Mediterranean in 2015, 2000, around that time, and how the international community reacted, also because of that crisis in terms of promoting the global compact, compact for safe, orderly, and regular migration. I think here there's also, a strong message also in the sense that, if these processes are anticipated and they are regulated, then there's less tension, there's less possibility also for conflict, in the sense that this may also have, movements of population and disputes among population within the country may also be a source of conflict. So I think it applies in a different way. And we don't use in the second issues paper the catchphrase that you were mentioning of stability, predictability, and certainty, but certainly the having clarification in terms of legal categories, legal protection, and promoting also, some people speak about migration as adaptation, migration, legal migration, regular migration as a possibility of adaptation to climate change and sea level rise. I think that goes also in the same direction.
Thanks. So it sounds, Nilüfer, like you and Bogdan can trademark that phrase if the second issues paper hasn't taken it up. I want to go back, Nilüfer, to some of the conclusions that you made in the first issues paper, and in particular the conclusions around ambulatory baselines, because I think they were done in a way that was very subtle. In that you didn't say that the treaty requires ambulatory baselines or that it doesn't require ambulatory baselines, but rather say that states have expressed concern about stability and ambulatory baselines don't meet that concern. And we know from the work of the ILA that they were unable to make a conclusion on sort of custom in relation to ambulatory baselines. In the work over sort of the past few years, have you seen new custom developing? Is there sort of a clearer engagement on this issue of ambulatory baselines from states than which we saw in the past?
Yeah, so this ambulatory baseline, indeed, we did take a cautious, but I think, to be quite honest, my personal view, I'm not convinced that the Law of the Sea Convention is so clear at all, that the Law of the Sea Convention requires ambulatory baselines. That's my view. There are others in the Commission who disagree. I think actually Bogdan is also of that view. But there are different views, so I think we don't want to have too much controversy on that, because ultimately, what is more important for us is saying, listen, whatever your view is, it doesn't meet the needs. The Law of the Sea Convention, in fact, the whole low water line, those were all from practically the 1930s. It's not even during the 1970s when the Law of the Sea Convention was being negotiated. So this is all very much pre-climate change period. So it wasn't taken into account at all. And so what we want to look at is an interpretation of the Law of the Sea Convention that will take into account the current situation of climate change and sea level rise. The ILA, actually the original baselines committee did conclude that the baseline was ambulatory. I think, and Patricia is actually a member of the ILA Committee on Sea Level Rise, they may have not been quite as convinced as the baselines committee, so that I think they took a less, didn't make it as clear, that issue of ambulatory nature. But I don't think we should focus on that actually, because it doesn't get us anywhere, to be quite honest. I think the question is, okay, how do we respond? How do we adapt? And you mentioned, I think Jose mentioned earlier, adaptation. We need to adapt to this reality. And I'd like to take the position that international law also should be a tool of adaptation. And it may just be that the right circumstances, in this case, sea level rise, climate change, preservation of existing lawfully established maritime boundaries and zones should be preserved. And I think that, so the state practice is emerging, particularly, as you know, Bryce, from the Pacific Islands. They have been at the vanguard. They're really moving this forward. And I think you're going to see more states catching on. And I am looking to Asia, some of the Asian states, particularly Southeast Asia, who are realizing the seriousness and that practice is forming. But to be quite honest, there's not a lot of practice. There are some states that do openly take the view that it's ambulatory, but I have to say, and I don't want to go on, but the US, for example, is interesting. On one hand, they take the position that baselines are ambulatory. On the other hand, if it's a boundary agreement, then that is not ambulatory. Maritime boundary agreements are preserved. So that to me is inconsistent, frankly. So, but I'll stop there.
I think one of the other things that was sort of quite interesting about the Sixth Committee discussion of the report was the number of states that came out and said that they didn't think that baselines were ambulatory. I remember sitting there and with a bunch of students, we were sort of taking notes, and we used to have a little checklist of the states that made comments, and there were a number of states which I was surprised, or hadn't heard anything from them before. So Patricia, you in your introduction, you talked about how there's sort of no sort of dedicated legal framework to deal particularly with this issue of protection of persons in relation to sea level rise, but that there is a good amount of existing international law which may be applied to this situation. And not to preempt what comes out in your report, but could you talk about some of the principles that you see sort of emanating from that existing body of law that applies to this situation of protection of persons in the context of sea level rise?
Yeah, no, I mean, I think it's one of the main conclusions, but I think, you know, it's something that was already clear, maybe not so much as the ambulatory or fixed baselines debate, but I mean, I think it was very clear for everybody, even before we made the report, that there was no specific category for legal category in terms of protection of persons affected by sea level rise. I mean, this it doesn't exist in any treaty. It doesn't exist in any binding instrument. So I think we're all clear that you know, when we speak about climate refugees, and also to answer a question that has been in the chat for a little bit now, I mean, there isn't any specific category, and the current refugee definition does not apply in the sense that only if people that are outside of their country and cannot avail themselves from the protection of that country because of reasons of prosecution based on political, religious, etc. motives. Only if there was some coincidence in the two situations would the protection of refugee law apply to people that have to move because of sea level rise. So only if there is, I mean, the strict criteria of the Refugee Convention are fulfilled. And so if we look at other bodies, I mean, if we look at human rights law, there isn't a specific reference in any binding instruments currently. And so what we see is that you know, there is some soft law instruments that have started to address this issue, and especially in the disaster law area. And if we look at the, for example, the Sendai framework for disaster risk reduction, or the Nansen initiative that drew up a protection agenda for people that are displaced by climate change or disasters, then we see some very useful language in terms of the principles that should be applicable to these situations, in terms of states having a duty to prevent this type of situations, or states having a duty to protect the human rights of persons that are affected by these situations, of ideas such as, and I think it's very interesting, and both Nilüfer and I, we just had a very recent experience where we had a training course with PIF countries that just finished yesterday. and you know, and in the discussions, I mean, it's very clear that if given the choice, most people affected by sea level rise would prefer to stay. They would prefer to stay and remain in situ. And so, for example, ideas that are from human rights law and environmental law, like having public participation in the decisions for if there is the possibility of relocating people, so that instead of people being confronted with the decision, the public participation aspect, and if there is disagreement or conflict, the access to justice aspect. So those principles from human rights law and environmental law of public participation and information and access to justice, I think, are very important before states take decisions. And then, for example, when as I mentioned before, and I think that is going to be, I mean, the Human Rights Committee in the Tetiota case ended up by deciding that in the concrete situation and in the time frame that we live in, this was not yet a situation where there would be the right to life or the right to not to be treated inhumanely or degradingly, did not yet materialize in territories affected by sea level rise, but in the time frame of about 10 to 15 years, that could be a case. And so the obligation of non-refoulement, which is an obligation from refugee law, but also from international human rights law, that would be applicable to people that are outside of their countries and could not be deported back to their countries of origin. So there are a number of existing obligations and also a number of principles that have been applied to disaster and climate change law and soft law instruments that I think are the basis of what could be, I mean, a regime for protection of persons affected by sea level rise. And this is what we try to discuss in the issues paper and also guide the discussion of the study group in this sense.
Thank you. So I want to pick up on one of the questions that was asked about sort of the role of China, whether or not it has positions on sea level rise, and then its engagement with small island states, and then pivot to a question for Nilüfer. So to the best of my knowledge, when China made its statement in the Sixth Committee, it didn't express a preference for ambulatory or non-ambulatory baselines. But it did make a comment about how sea level rise poses an existential threat to small islands, and that the ILC should certainly be considering that existential threat. China actually has been working in the Maldives, which is the lowest lying state in the world. Highest point above sea level is about 1.5 meters, although China has been working actually to not fortify, but to raise the height of the large island that's beside the capital through dredging and such. In the first issues paper, you make this conclusion that it's certainly possible for states to fortify their sort of outermost points. And that certainly may work for a state that doesn't have sort of a large number of outermost points which may submerge, or a state which has sort of resources. But that doesn't apply really to most of the small islands, and indeed, actually, I would say most of the countries in Southeast Asia. Do you think there's an equity issue at play here, where rich states could fortify and therefore protect their land, and other states without the resources would not be able to do that? It seems like this is that this would sort of not be a good situation, not an equitable situation, and would, I think, really call into question this idea of equality that exists in UNCLOS.
Yeah, thanks, Bryce. Again, another excellent point you raised, and absolutely is a huge equity issue there. And of course, the ability, I mean, it's been done for centuries, you know, Netherlands has been, you know, keeping the sea off its shores through dikes, and, you know, that's basically, you know, against sea level rise in the sense of because they're so below level. So international law does accept the use of artificial means to preserve, or we do land reclamation. I mean, Singapore does land reclamation. But what you cannot do, and I think that that came out of course, the South China Sea case, is to create from, for example, a rock, an island, or a low tide elevation. So you can maintain the status of an island, for example, but whether you can create a new status is something else. But what we're looking at is preserving the status of an island through artificial means. And I know you mentioned Maldives. Now there's a question there from Maldives as well, someone from Maldives, I believe, where they are building, it's Humale, an artificial, you know, city. And there's industry built now for artificial islands. I mean, it's a big industry actually, but they're very expensive. And it is unfair because I think I want to just go to a point that Patricia made, and this is somewhat related to the loss of statehood. You know, people don't want to move. You know, a lot of they're very, the idea of having to be displaced. Well, one way, of course, is how much can you preserve the territory you have through artificial means. It's not ideal in terms of that wouldn't be necessarily the same land, it's artificial, but at least it would prevent the displacement, but extremely expensive. And so there is a huge equity issue where, for example, Singapore can invest $100 million and maybe more to take those adaptation needs. But many of these small island developing states or large ocean states don't have that financial resource at all. And that does bring us to a whole issue of loss and damage, which we won't go into. So yes, you're absolutely right. And I think that this is something that needs to be addressed.
Okay. Jose, in our discussion the other day, you had some questions about sort of particular orientations of Asian states towards international law and the implications that this may have on the work on sea level rise. So I wanted to give you a moment to ask about that.
So actually, I have a ton of questions. Only one of them, but I did want at this point, just because I said it at the outset, just to go back to Bryce for a minute, and just from your position as a lawyer for the small island states, and given the fact that I suspect there are some of my students tuning in who are avid students of the Montevideo Convention, how do you argue that a sinking state still adheres to statehood? I mean, what is the basic argument? Because it sounds to me like every one of the categories of Montevideo territory, whether it has a functioning government and whether that government could be permanently in exile, does it have a permanent population? And if a bunch of states decide to not recognize and not have diplomatic relations, a former island that has disappeared or has become uninhabitable, I know we have the declaratory theory, but at some point, reality does set in. But how do you make the argument that sea level rise, especially with many of these islands, is not a threat to their continued enjoyment of basic statehood?
Okay, I'll try to be super quick here. So first, and this also sort of relates to the negotiation of UNCLOS, the vast majority of small island states, well, I think actually almost all the small island states didn't exist as independent states in 1933 when Montevideo was negotiated, and still the vast majority didn't exist as independent states when UNCLOS was. And so whether or not these rules from 90 and 50 years ago sort of take into account the interests of these states is a big question. And so we are always asking, should these rules govern this current situation with these current states? We also think that Montevideo, well, I'm not sure that we all think this, but a common thought is that Montevideo may sort of be a one-way type of situation. So you are required to have those 4 characteristics to become a state, but the maintenance of those 4 characteristics are not necessary to maintain statehood or sovereignty. And there are a number of examples through history where one of those 4 characteristics no longer exists, but we still consider that entity to be a state in international law. And sort of to link this to Nilüfer's earlier point about sort of protecting and freezing baselines, it certainly would be possible if we froze baselines, capped EEZs, capped internal waters, that particularly on the territory question, and I think it's important that Montevideo doesn't mention land territory, it just mentions territory. And for many small island states, their ocean territory is intrinsic to their concept of sovereignty, that we can sort of protect that over time and therefore keep statehood. And then to sort of come to your final question, that at some point, the physical reality is going to diverge significantly from the legal reality. And in that situation, I think we have to ask ourselves, well, which states would be challenging that? It's unlikely that small island states are going to be challenging the sovereignty of other small island states, and quite possibly that developing states won't challenge that. So it would very often be large developed states, the ones that are sort of engaged in international law, in the work of the ILC, in the work of the Sixth Committee. And these large developed states would then be saying, essentially as a result of our actions, of our emissions over centuries, these other states have disappeared, and now we want to remove their sovereignty. And so again, we have this question both of equity, but also really sort of clean hands. Is it appropriate for the states that have caused this to then somehow benefit from it?
No, that's an excellent response. And I guess I just a bit of a follow-up. So if you look to the end game, you're describing a resolution based on political state practice. But is there any role here for, not as a short circuit, perhaps as a complement, to turn to ILC and its advisory jurisdiction, or to turn to the ICJ and its advisory jurisdiction with respect to a basic issue like statehood? Do you see a role for international courts on that basic question?
So there very certainly is a role really for either of those courts. I think it's a question really of timing. There is a very interesting discussion that has been started by this consideration of sea level rise in the ILC. We have received an excellent first issues paper. I'm expecting that we're going to receive an excellent second issues paper. And it has resulted in this very interesting discussion between the ILC and states on these issues. I think always that a political solution between states on this issue is going to be more durable than, well, certainly an advisory opinion from either ILC or ICJ. So what I would say is that let's allow this ILC process to continue. Let's allow states to continue to consider it. And we may have some resolution from that. If at the end of this, we don't have resolution, if there's still sort of large questions that are outstanding, then yes, very certainly, there is a role for these international adjudicatory bodies to weigh in.
So I guess now that we're getting towards the end and one of our traditions is to actually close at the right time, I wanted to raise questions for both Nilüfer and Patricia. And so what is, for both of you, what do you think would be the end game in terms of what the ILC's role is here? That is one of the guardrails that is established, and it's totally understandable for political reasons, given how much you interact with states. I'm not surprised by it, but as I understand it, you're not supposed to be proposing changes to UNCLOS itself. And yet you've indicated that UNCLOS didn't really have an answer to this. So in the old days, the solution is the ILC would propose a new treaty. And of course, in maritime areas, that was what the ILC did regularly until UNCLOS came down, but it was regularly doing treaties. And I know politically why that makes sense. But if you take your hat off as an ILC person, isn't it really true that what we really need here is to adapt UNCLOS to this new reality? And I guess with Patricia, it's a similar question. You've suggested there is no legal regime that deals really with this kind of migration. And let's face it, the human rights treaties tend to focus on how a state deals with its own population and not so much on extraterritorial obligations to other countries' nationals. So there too, don't we really need new treaties, if only to establish much more clearly the duty to cooperate, which I think is essential to both the projects here, both the law of the sea as well as protection of persons. So I guess I want to raise the guardrails under which you operate. Will that really make it very difficult for you to make a meaningful contribution? Nilüfer, if you want to start that.
Okay, all right. Yeah, thank you, Jose. And I think it's really a very important question. So in terms of the Law of the Sea Convention, I have to say that, in fact, when I was first campaigning the first round, I always mentioned that the Law of the Sea was the first issue on the agenda of the commission when it was first established in 1948. And it would be great to see it back on the agenda, and it is. So I feel that we do have some propriety over this issue. Having said that, it's understandable. States are conservative. There's concern that the ILC will come in and immediately start proposing amendments. And so we understand that. On the other hand, I think that because there is this big gap, and for us in the ILC, it's a question of how we formulate. And I think so far, our role is to guide this discussion. And I like to think of it, that giving it the right momentum. And I think Bryce is giving good feedback. I think ILC, the first issues paper, did provoke a good discussion. I was at the 6th committee as well, and the comments were overall quite positive, actually. That's good. So whether we won't necessarily come out and say amend, but it could be a question of finding interpretation, the ILC using its authoritative voice to assist and facilitate the interpretation of those gaps. I think what's really important is that we develop a good, solid relationship with states, so that there's trust as well, and that the ILC will be looked at to offer that guidance. And I think particularly with the Pacific Island states and other states, I feel that we do have that, but it's enlarging that. group as well. So I think the ILC has an important role, very constructive role, and that the end game should be finding that solution because we need one. And I like to think that the ILC will actually be an important part of finding that, filling those gaps in conjunction with working with states on this.
So over to you, Patricia.
No, I would just add, and mindful of the time, that the way that we are working, and this was a very conscious decision, to propose a study group with a mandate to do a study and a mapping of the legal questions and then possible recommendations, was also due to the recognition of what we mentioned before about state practice not being as developed as when we work with other topics and when we are in a more mature stage. So I think here really the purpose, and I don't know, I think it's too early to say what's the end game at the end, the real end game. But I think our mission, as Nilüfer said, I mean, and that's really what we got as a mandate from the Commission and with the support of states, is to clarify the legal issues and provide a solid basis for the political discussions of states. If in the end, it will be through interpretation, political declarations, treaty amendment, I think that there's something that still remains to be seen. But our task, and I think that's helpful for the international community and for states in particular, is to have a solid, objective study on the legal issues so that then the political considerations can come in.
Thank you. That's quite helpful. And of course, there's a line through the three topics here. Obviously, if you're no longer a state, you are stateless. If you are stateless, you may not have human rights. And the reason that you may not have rights is because perhaps the law of the sea takes those away. So I'm very much looking forward to not just the individual reports on these three topics, but how the ILC will put them all together. And I do think that the ILC's efforts on the soft law side have been useful. I think its fragmentation projects was useful. And I do think that the Articles of State Responsibility, for example, which never became a treaty, and perhaps are most useful because they didn't become a treaty and ended up with some common denominator problems. So I'm very, very grateful to both of you and Bryce for taking the time to do this. I'm also grateful to the APEC Center of Columbia University, which helped to put this program together and helped us, and it's promoting it on their website. And so I look forward to seeing you both back on further reports from the ILC, with perhaps Bryce again serving the noble role of interlocutor, so that we can regather perhaps a year from now, see where we are on these topics. And I thank you, the audience, for some very good questions in the Q&A box, which hopefully we at least attempted to answer, and look forward to seeing some of you back for the third Gillette Dialogue tomorrow. Thanks you all.